welcome to our panel on encryption, a topic that keeps managing to stay relevant and high profile year after year, mainly due to a number of standoffs between the FBI and certain tech companies I'm sure you have heard about. As most of you probably know, the most recent flare-up occurred in the wake of the tragic Pensacola. William Barr is surprised there is not yet a solution to the problems encryption causes for law enforcement. Some feel tech companies and law enforcement should come up with a solution on their own, and others maintain that Congress must legislate on this or there will be no clear path forward. We're going to discuss during today's panel what the path forward is and hear some examples from how other countries, such as Australia and the UK, have grappled with this question. We've got Brendan Dowling from the Australian Embassy Department of Home Affairs. We've got Sujit Raman, Associate Deputy Attorney General at the US DOJ. Tom Rutherford, the Head of Encryption and Online Safety at the UK Foreign and Commonwealth Office. Jim Baker, the Director of National Security and Cybersecurity at the R Street Institute, formerly at the FBI as General Counsel. Daniel Weitzner, the Principal Research Scientist at MIT, and Amie Stepanovich at Silicon Flatirons, formerly of Access Now. And yeah, I'm going to start off with a simple question I want all of the panelists to answer. What does a reasonable solution to the issues pitting law enforcement against tech companies on encryption look like to you? And we can start with you, Jim.
Thanks very much, and thanks for having me here. So the reasonable technical solution would adequately balance the needs of law enforcement, make sure that there are enable American companies to remain competitive and innovative, protect human rights around the world, and do all these things simultaneously in a way that was secure and reliable. Such a thing does not exist today. And then that's why we're here. That is the problem. But that's what it would look like. Mm-hmm.
I also thank you for having me. So I actually, if it's okay, actually wanted to just go back to the impact and just make a point about that, because that's why this is so important to have this debate. So, and it's really important to the UK government. So I'm really pleased to be here. And we really support strong encryption, but actually the impact where companies design their services in such a way that there can be no access to content is really severe, and it's in two distinct ways, and hopefully we'll talk about that a bit today. The first, which I think is where the debate on this issue usually finds itself, is on lawful access under warrant to the content of communications. But the second side, which is just as important to us, is by eroding companies' own ability to tackle the most serious illegal content on their platforms. Now, in terms of what a solution looks like, we believe that there can be solutions that balance all of the interests that Jim has mentioned, and we don't see that that's a binary choice in the UK, and we don't think that those interests are all competing interests. And we also believe that legislative solutions are possible on this issue, and we have in fact passed legislation in the UK in the Investigatory Powers Act, which I'm sure we'll talk a bit about later.
So I'll keep my comments pretty brief because I know we have a number of panelists. I 100% agree with Tom, and I 95% agree with Jim. I think a reasonable solution is one that draws a balance between significant, important privacy rights that are enshrined, at least in our tradition, under the Fourth Amendment, while providing lawful access to law enforcement as appropriate, as required by a court order. Those mechanisms exist today. How many people here have a Gmail account? Almost everybody, right? If you use Gmail, you are engaging in the kind of communications that balance privacy, right? Those messages are encrypted from when you send that message to Google's server, from Google's server onto the recipient. It's encrypted in transit. It's protected on Google servers. And yet Google maintains the ability to look at the content of that information in a decrypted way, to screen it for malware, to make sure that it's not passing on a virus, and also to respond to lawful court authorization. So Gmail is a product that protects cybersecurity and yet permits investigators access with lawful authority. That's all we're asking for. Who uses Facebook Messenger? As currently configured, Facebook Messenger allows for lawful access. It's a secure means of communication for the average person out there who's using it. And yet, the way it's architected, there is the ability for law enforcement with court authorization to seek the content of communications. Those models exist. I haven't heard Google suggesting that Gmail is riddled with cybersecurity vulnerabilities, and if so, they might have some disclosures to make in their Form 8Ks. I haven't heard Facebook suggest that Messenger, as it's currently configured, is riddled with cybersecurity vulnerabilities. And if so, they should probably tell somebody. No, those products are secure from a reasonable sense when it comes to cybersecurity, and yet they provide the opportunity for law enforcement with appropriate court authorization to access content.
Said you were going to be brief.
It was very compelling, though. I think the way we put it is there is a question of lawful access, but more broadly, what the Australian government has pitched to companies is that there is not a single industry-wide solution to this issue. But what we'd ask is that all platforms and all across industry, that safety of the community is foundational to design, that when companies are considering implementing forms of electronic protection, that they consider how their platforms might be used by criminal networks, by pedophiles, and how they can mitigate the use of their platforms for those purposes. So companies will find different solutions. There are lots of technical experts out there who can work on those solutions. This is not about saying there should be a backdoor to all encrypted mechanisms deployed by any part of industry. There are a range of different mechanisms, none of which in of themselves are the totality of the solution. But let's all agree that one of the first principles of design should be, let's not make it easier for pedophiles to use our network. And I know that sometimes becomes a emotional argument, particularly when we talk about the protection of children's. I don't think we should shy away from that. When you look at the proliferation of that sort of material that is happening, this is not a static problem. This is a worsening problem. And while we fail to find those solutions, this is something that in government we look at and say, it is untenable, the trajectory that we are on. So reasonable looks like putting that problem first, investing time, effort, skill in developing solutions, and engaging in a constructive debate between government and industry on what sensible regulation, workable regulation looks like to make the online environment as safe as the offline environment is.
Amie?
So it's hello. Sorry about that. It was green, and then I went to speak, and it was red. I feel like there was an issue that happened there. It's really great to be back in DC and having this conversation again. I've been participating in this debate for about 10 years now, so it's. I know, as many of you in the room know, it's nothing new. If any of you have gone through a digital security training, you know that the first thing they talk to you about is threat modeling. And not everybody has the same threat model, and you're going to use products and services that responds to what you particularly are worried about. And why I bring that up is because it's great. I feel like in DC, frequently this conversation becomes very much about the US, and it's not going to be that on this panel. But it's also not about Western governments. And several people's threat model is keeping their sensitive communications as activists, journalists, and other marginalized and vulnerable communities away from the governments that could arrest them or worse. And so this is potentially a very emotional issue, because for some of those activists, this could be a matter of life or death, whether or not their communications can be compelled from a government. And it's a global issue. And so I think, to answer your question, Ashley, a solution here is going to look at the fact that cybersecurity is frequently given as the number one issue that governments need to respond to, that we need to be able to allow companies to innovate to the fullest extent they're able to on the security issue if we're going to have any chance of surviving in not only an internet connected world, but an Internet of Things connected world, where your whole life is wired into a connected network. And that doesn't happen unless we're looking at the full entirety of the issue. And the internet has made an explosion of information available to law enforcement, more than ever in the history of communications. Is there an ability for law enforcement and other investigators to gain access to information? And encryption might have taken a little bit of that out, but there are other means and other methods for gaining that access back, and we can't leave those out of the conversation. We used to have very specific debates, Clipper chip, key escrow. I think some of what the lessons we've learned from the fact that those were technically proven to be unfeasible is that instead of having specific proposals, we would, in the obscure, say companies allow law enforcement to have access to communications, go figure it out. That hasn't made the problem easier. It's just shifted the public conversation to make it harder to argue against.
Thanks. So I agree with a large part of what has been said by everyone as broad policy goals. I think everyone ought to agree that surveillance is an important investigative tool that we should work to maintain. And I think everyone also ought to agree that improving the state of internet security is a goal that we should have. It's a mistake to think about internet security as something that's fine that we might lose. It's more like something that is desperately being held onto that imposes billions, hundreds of billions of dollars of cost around the world for security failures, so that we're not dealing with a steady state situation. We're dealing with what is really a kind of a rolling domestic security and national security crisis. I think governments recognize that, though they don't always recognize it in the context of this debate. Some do, some don't, and we'll get to that. What I would say, though, I would just add to the requirements that everyone has put on the table about what an ideal policy framework is. I'd add one, which is that we really have to be able to build a system in the context of whatever this policy framework is that's actually trusted around the world. We have, and what we know about trust in the cybersecurity world is that it only arises when we have transparent access to the design of systems that people are using. Trust only arises, security only arises when we can have lots of eyeballs on security problems and they can be actually improved over time. Security is not a steady state phenomenon. It is a constant struggle against dynamic adversaries and against increasingly complex systems that create themselves all kinds of risks. So we have to have a system, we have to have a policy framework here that produces trustworthy security. And what I would say to Sujit is that I don't think Gmail is a good example here, because email, the construction of the email infrastructure in the world is actually the source of a huge amount of the security problems that we have. Spear phishing is basically the major venue through which enterprises and governments and individuals are attacked. And it's possible because of the fundamental insecurity of email. That makes it easier for law enforcement. It's a very porous protocol. I'm not necessarily suggesting we should change it, but to hold it up as an example of a system that balances security and law enforcement needs is to misunderstand the security properties of that system. And in some sense, it's the experience of protocols like the open internet email that has pushed new protocol designers, mobile system designers, device system designers to try to tighten the security on their systems, not in order to thwart law enforcement, but just to make those platforms more secure. So
why don't we let him respond to that, and then we can move on.
Right.
Well, I appreciate Danny's points. Let me just say this. Brendan, during his presentation, said we need to think about safety, public safety, and ensuring that those values are incorporated into designs. Danny has spoken very eloquently about security. cybersecurity. But that's not the only value here. And Amie, I thought, spoke very eloquently about the rights of, or the needs of human rights activists, journalists. Completely agree with all of that. But let's not discount the young boy, the young girl next door who's being sexually abused by somebody, which is also a very significant factor. We've talked about this publicly. If Facebook end-to-end encrypts all of its platforms, as the company has said it plans to do, that will have a material, grave impact on our ability to investigate those crimes. So we have a lot of sympathy and interest in democracy activists in other parts of the world. We also just as equally need to keep in mind, if not more so, toddlers who are being sexually abused, and we will lose insight into those cases if end-to-end encryption is implemented. So my point is only this. When you think about the constellation of values, cybersecurity is important, privacy is important, user safety is important, public safety is important. And we shouldn't prioritize cybersecurity above every other value because there's a tremendous social impact when we do that. That's why I mentioned the couple examples that I did where these are consumer platforms that people use that are pretty well regarded for their cybersecurity. And again, technical experts might disagree, but I think when you've got basically 99% of the people in this room raising their hand, that says something about the balance that companies have struck between cybersecurity on the one hand and ensuring lawful access on the other.
Thanks, Sujit. Amie, just wanted to build on one point about what you said, Amie, about dissidents or journalists in repressive regimes. And actually, absolutely, encryption plays an important role in protecting those people and in those people's data. But we need to remember, we're not talking about the difference between end-to-end encryption that provides no access in any circumstances to content and no encryption at all. And I would just say, and I won't go into the detail here, but we have just before Christmas submitted a detailed testimony to Congress that outlines why we don't accept that just because a service isn't end-to-end encrypted in that way, it doesn't mean there's a material difference in the protection of those people in repressive states.
It does if not having the material end-to-end encrypted means it's accessible by a government that could go after those people in a way that infringes upon their human rights. And I would put back, if Facebook Messenger goes end-to-end encrypted, you make a good point. If one of the currently end-to-end encrypted messengers changes its protocol so that a intermediary does have access to the messages, do you think that it is not probable that the people you're talking about will just move to another platform? There will always be platforms outside the reach of a jurisdiction, regardless of, I know, jurisdiction in some of the laws that Australia and UK have passed is quite broad. But there will always be ways for people to do bad things on the internet outside the reach of government. Who you will take security away from are the billions of people who use it and rely on it in their everyday lives, who don't know that they're being targeted by governments.
That brings me to my next question for you is, what can the DOJ actually do if Facebook doesn't listen to your plea for them to not to incorporate end-to-end encryption in all of their messaging apps? What are your options there, and what has your latest communication back and forth with Facebook been on that topic?
Well, if I could, let me defer to my colleague Tom, just because the British government, and along with the Australian government, has actually been quite vocal in raising awareness of this issue. I'm happy to answer the question, but perhaps, Tom, if you want to take the lead.
Yeah, thank you, Sujit. So, I mean, it goes back to the point that I made at the start about impact, and I think that's why we're so concerned about Facebook's proposals. I mean, we set out in an open letter to Mark Zuckerberg, which people will be aware of, the scale and severity of that impact. And the National Center for Missing and Exploited Children estimate that we are talking about the loss of 12 million reports every year of child abuse. And in the UK context, in 2018, that would have led to 2,500 arrests and 3,000 children safeguarded. So that is what we stand to lose here. That's really quite serious. And in terms of the asks of the company, they were set out very clearly in our open letter. And just to reiterate what they are, they're points we've already made and Brendan made at the start about embedding the safety of users in systems designs, ensuring there is the ability for lawful access where governments have a warrant that is necessary and proportionate and lawfully authorized. Crucially, consulting governments in the level of technical detail that is necessary to really make progress and have a substantive influence on how those designs implementing those systems are fully tested and operational. Now, you asked about progress in terms of the debate. Those key asks from that open letter all still stand. We are, of course, still seeking to engage the company, including in the level of technical detail that I have just described. I don't intend to give a running commentary on our engagement with the company, but it was publicly reported, for example, that there was a meeting last week between our Home Secretary, the Culture Secretary, and the Prime Minister in the UK, and Sheryl Sandberg, the Chief Operating Officer of Facebook. And this was an issue that was discussed in that meeting. And it, as I say, it's crucial that we can continue to have engagement with the company, but that engagement must be substantive and in the level of detailed technical engagement that we really need.
Can I just jump in
Sure.
real quick? Yeah. So having been at the FBI during the dispute with Apple in 2016 and having worked in the Deputy Attorney General's office on this issue, I don't know, 10 years ago or so, and having been involved in this issue for a long, long time. At the end of the day, it seems to me that DOJ has really two options. One, go to court and get an order that compels one of these companies to do that which they want it to do, and force them through a court order and have that order survive all the way through appeal, probably to the Supreme Court of the United States. The other more logical way, I think, is to get Congress to do something and pass a law that requires companies to do what the Department of Justice and other law enforcement entities in the United States want them to do. Congress has known about this problem for years and years. This has been talked about. We talked about it at DOJ. The current folks at DOJ are talking about it constantly. So Congress is well aware that there's a problem, and yet they haven't done anything. Why? It goes back to what I said earlier. There is not a clear technical solution that addresses all these equities in a reasonable way simultaneously, that does not expose the country and our allies to enormous cybersecurity risk, which we already face because the systems are so poor, basically, in terms of cybersecurity. The threat actors are so numerous and sophisticated, and society relies so heavily on these systems for all of its essential functions. The health, safety and welfare of our societies, of our citizens, rely on these systems, and they just are not as secure as they need to be. So in my view, society faces an existential risk already because of the cybersecurity posture of the U.S. and our allies. So the entity in the U.S. that should balance all of these different equities and pass a law is Congress. They won't do it because they're nervous about passing a law that ends up creating a situation where the United States is less secure. One last thing. The UK and Australia have already passed aggressive, robust laws in this area, and we're still here talking about it, right? And it hasn't solved the situation. Again, why? I don't know why the folks are here. Maybe they can talk about it, but it seems as though those governments are not willing to confront the companies because society itself relies so heavily on these encrypted systems, and it's just not a choice that they're prepared to really push at this point in time.
Mm-hmm. Could I just add that I think that I'm interested to hear from the UK and Australia. To my mind, there are some things that we can really learn from what the UK and Australia have done, and I'd name two. Number one. Both of these countries, as Jim said, have actually decided to give themselves authority. So right now in the U.S., the authority is at best unclear, and the requirements on companies are completely unclear. the UK and Australia have said, okay, we're taking charge of this situation. And I think that's a credible thing for governments to do. Can I just say the second thing is that in both cases, both the UK and Australia law recognize that any requirement imposed on companies has to address the real possibility of technical risk. The UK law says that there cannot be technical requirements unless they are technically reasonable. The Australian law says there cannot be technical requirements that impose what is called systemic vulnerability. That is, vulnerability on the users of all systems just for the sake of getting to the communication of one user. And I think these are pretty important points. I think they actually reflect progress in the debate. They reflect instantiation in the law that this balance has to be struck. And what I will say is that over the history of the debate about different technical approaches to exceptional access, starting with the Clipper chip in 1992, not one proposal that has been made for exceptional access has survived even the simplest technical scrutiny. Every proposal that has been made has technical flaws in it. And luckily, we've had an environment where we've been able to look at those proposals publicly. The only thing I would criticize about the UK and Australia approach is that they shroud their requirements in secrecy. So independent technical experts, at least in the current systems in Australia and the UK, will not have the opportunity to evaluate whether, in fact, the technical requirements meet basic security standards. And I think that's something that we have to take into account as well.
Brendan, can you give us some examples of how the law in Australia has worked out in practice, and how has that actually helped law enforcement, and what are some case studies there?
Sure. I'd just make just going back to the Facebook comment before I get into Australia's law. One broad point. I think we zero in on the lawful access question frequently, but what we're actually talking to companies like Facebook about is how do you make your platform hostile to what everyone agrees are abhorrent and criminal activities? And the child abuse issue is the one that is at the forefront of our mind. That is not to say we are saying, Facebook, we will stand in your way and we will prevent you going to an end-to-end encrypted environment. It's saying there's something unique about your platform, that you combine a private messaging service with an open platform that makes you particularly a preferred platform for people who are distributing child abuse material to surface into the clear web. Now, there is no one who thinks that's a good thing. Facebook doesn't think that's a good thing. The conversation we're having is, what are the tools, what are the mechanisms that do not necessarily jeopardize your wish to have increased privacy for your consumers, but also meet the needs to make your platform hostile to these operators, whether that's scanning and upload, whether it's applying hash sharing technology in an encrypted environment. That's the sort of constructive argument we want. A debate we want to have. It's not about
is that
zero
not
sum.
a debate you're having yet?
I think that's a debate we've asked to have, as Tom has indicated. I am not optimistic that we're currently engaged in a constructive process at this point, but I'm hoping that's where we can get to.
And before we get into Australia's law, can we hear from our own DOJ about how conversations with Facebook are or are not ongoing on this topic?
Well, I think the Attorney General issued his letter in October. I believe Facebook provided a public reply in December where the company essentially doubled down and said, we're going to implement this. I think they had a company representative speak at one of the crypto conferences in New York just a few days ago, where the company reiterated that it has no plans to alter its currently announced plans to implement end-to-end encryption. I think that's where the conversation currently stands from a public perspective.
Thank you. And Brendan, if you could give us some examples of how the law is working.
Sure. So the first thing to understand with Australia's assistance and access legislation is that it doesn't solve this problem. It's a initial foray into finding a cooperative sort of framework for law enforcement and industry to work together on addressing this issue. So we passed this legislation in late 2018. Essentially recognising that there were, the estimate was around 90% of national security or serious criminal investigations were being hampered in some way by encryption or otherwise online or digital technologies that were disguising communications and content. The legislation was extensively consulted in the run-up to being passed. There were significant private consultations with major industry players. The legislation substantially changed as a result of those consultations. So the suggestion that we've heard after the fact, some complaints that there wasn't sufficient consultation is completely untrue. As many of you know, involved in government consultations, we don't always substantially change things as a result. This is an example where legislation did change. It was passed. It has a few core powers in relation to this issue. It can allow law enforcement to issue notices to industry to seek assistance with accessing a form of content or data or communication. That can only happen once there has been a warrant authorised to get to that communication. So this legislation in of itself has no powers to access content. If a warrant exists and if that content can then not be accessed, the legislation gives law enforcement the power to issue a notice seeking the assistance of industry. The first form of that notice is a voluntary request. The second form is a compulsion to provide assistance for law enforcement on the basis of existing capabilities. The third power, which is yet to be used, is a technical capability notice that asks a particular company to develop a capability to allow access to a form, to some content. Now, it is expressly prohibited under law from using that final power, which is the one that has generated the most sort of heat and angst, to remove or to create a capability that doesn't already exist to remove any form of electronic protection. So the notion of a backdoor or a vulnerability to the system is expressly prohibited under law from the Australian government from seeking. To date, sort of 13 months or so after the legislation was passed, the powers have been used handfuls of time. I think in the run-up to passing the legislation, with assurances from the government that there would be sufficient review, oversight, and that the laws would be very limited in their use, is exactly how it's played out in practice, in being used handfuls of times.
And would we be able to see any evidence of the limitations of the use?
So the limitations, what I mean by that is that it only applies in a warranted environment. It doesn't allow...
We don't know anything about how the law has actually been used in specific cases, right?
I can give you the short answer is no. As with most investigations, we don't publicly disclose exactly how the material is discovered, but there is reporting around how frequently the legislation can be used. But I want to give one important example here, which is that in most of the cases, a voluntary notice has been issued and the company has complied with the notice on a voluntary basis. There have been some cases where companies have asked us to issue a compulsive notice for whatever reason they decide they would like to be compelled by the government. But the broad point, I think, to understand is that, by and large, this happens in a cooperative way with industry. This is not a draconian power that's being used by the Australian government. This is something that, in the course of any investigation, with strong relationships between industry and government, a conversation occurs. Here's what we're looking for. Here's what our problem is. In what way can you assist us?
These orders ever become public?
No, they won't become public.
So that's pretty unusual. I mean, we wouldn't have that in our legal system except for national security.
Sort of hearing how
matter.
this law works in Australia, would a law like this ever fly in the US? For any of the panelists? Amy?
No.
Why is that?
The gag provisions are way overbroad and would probably violate the First Amendment, as well as the ability to compel code to be changed by a company. I would say the voluntary capability, the technical assistance notices are probably, and though we will probably never have information about how they're being used, may likely be just a waiver of liability for companies that are already leaning toward providing this sort of access anyway, and prevent them from being having litigation brought against them by the users who could be affected. But without that level of transparency and with that compulsory need to change code, there's a very real First Amendment issue here. I think instead we'd be looking at the All Writs Act that was used in San Francisco, in San Bernardino, and because that was never brought to court and withdrawn, and by all intents and purposes, the reporting says that was mainly brought to be political pressure on companies anyway. I don't know if we'll see that being used again.
I think just one important point to add, a lot of this cooperation has been going on for a very long period of time. Before the internet, communications providers in any form, this cooperation has been going on for decades. There is a view from some quarters that there should be more transparency around that cooperation, but this is not actually a new issue. This is the issuance of notices, the issuance of the cooperation between law enforcement and communications providers is a long-standing practice, and the disclosure of that information in the same way that you wouldn't disclose the contents of a warrant in the public domain, when it gets to the specifics of a law enforcement investigation, not all information is made public for good reason. And in terms of looking at the assistance that a company may provide and what capability they have to provide that assistance, in most cases, industry doesn't want that information out there either, because it's about their cybersecurity, it's about their practices, it's about commercial in confidence provisions. So the idea that we should have transparency around all these sort of mechanisms, I don't think is something that has flown in the past.
So I think it has.
Can we actually switch gears real quick? We're running out of time a little bit. I want to ask about the Cloud Act and how it treats encryption. The Cloud Act is supposed to be encryption neutral. So when the US is figuring out its data sharing treaties with countries such as the UK and Australia, how is encryption talked about? And if it can't be addressed in the Cloud Act, are you guys working on other solutions together? We can start with you.
Yeah, absolutely. So are people familiar with the Cloud Act? Pretty major legislative accomplishment from about March of 2018 that essentially allows for the United States to enter into executive agreements with rule of law, respecting privacy, protecting foreign governments to aid in the sharing of information and data for law enforcement purposes. As is publicly known, we negotiated the first such agreement. It was with the United Kingdom just a few weeks ago. Those materials have been sent to the Congress, and there's now a 6-month period where those issues can be evaluated, and we expect the agreement to go into effect around this summer. The Cloud Act legislation is encryption neutral, so it actually says there's nothing directly impacted by the legislation. Countries that we engage with are free to enact whatever legislation they'd like in the encryption area. So the Cloud Act neither creates new obligations or rights or detracts from existing obligations or rights. It's up to the countries that we deal with, including the United Kingdom, to decide under its own domestic law how to deal with the question of encryption. So they really are quite separate. The legislation, the Cloud Act legislation, was crafted to specifically not take a position on encryption one way or the other.
And if I may add to that, so I'll touch on the Cloud Act, and then if I could just touch on the UK legislative position and how it relates to encryption. So as Sujit said, Cloud Act is neutral on encryption, but actually it is relevant to this debate, and I think it's really important in the context of the discussion we had earlier about access from repressive states, because actually these sorts of international agreements provide a really important framework for the future because they're based on international human rights standards, different countries having safeguards and independent oversight of their investigatory powers regime. And frankly, repressive states just would not be able to meet those criteria. So I do think it's relevant to the debate, despite the fact that it's encryption neutral. And then in terms of the legislative position in the UK, We have the Investigatory Powers Act, which does include specific provisions related to this debate. It enables the Secretary of State to give what we also call a technical capability notice, although they're slightly different to the Australian laws, clearly. And those do enable us to require companies to maintain the capability in certain circumstances where they are lawfully issued with a subsequent warrant to provide content in an intelligible form. Now, the giving of those notices is subject to really, really robust safeguards. They have to be approved by the Secretary of State and a senior judge. They must be necessary and proportionate. The government must consult the company involved. There's tests around what we need to consider, factors around the likely benefit, technical feasibility, any other impact on the operator. As I say, those safeguards are really robust. We consider them to be world leading. It's not just us that's saying that either. The UN Special Rapporteur on Privacy considered our law in significant detail back in 2018, and he concluded that the UK can position itself as a global leader on this issue, given the amendments that we had made to our law in this area. So that's our legal position, but I think it's really important to note it doesn't preclude the need for detailed technical engagement with industry about real, reasonable solutions. And Danny touched on the legal test that we have, and it boils down to, for us, what is reasonably practical for a company to do. Now, to determine that, you need to be speaking to individual companies to understand their technical architecture and how their systems work. Also, just to address your point, Danny, about transparency, I agree. Transparency is really important in this debate, actually. And we as governments need to try and say everything that we can about what we are trying to achieve and what we are trying to do. We've done that in the UK by setting out a number of principles that we'll adhere to in our engagement with industry in an article on lawfare that was published by GCHQ in 2018. The last of those principles is, in fact, transparency.
And I think there's going to be a real test of that, because ultimately, the technical community will not trust new technologies that are imposed on companies if they're secret. They simply won't trust it. And actually, the thing is, they'll be discovered, because it's very hard to hide any of these new features anyway. And I give the UK and Australia a lot of credit for working on engagement. I think it's unfortunate that you've both stopped short of actual transparency. And I understand there are reasons why certain kinds of techniques need to be kept confidential. But what I would say is that internet security has never, ever worked when it's depended on secrecy and obscurity of methods. It's always depended on open standards and open design.
So just to come back on that specifically, it is a really hard issue, transparency around what are, at the end of the day, national security powers, right? So it's hard to strike that balance. We did actually say in that lawfare article explicitly that these sorts of modern end-to-end encrypted systems are subject to scrutiny by technical experts. Yes. And we may find ourselves in a position in the future where it is necessary for lawful access mechanisms to become public. We've said that previously. Now, that's a difficult question, and it would depend on individual circumstances, and it would be a difficult decision with various competing interests at play. But I agree with you.
And I would suggest...
Can we let Jim respond, actually?
Yeah, I just wanted to make a quick comment. As we're thinking about the way forward and potential solutions, and if I could put a plug in for some work that I did with the Carnegie Endowment for International Peace and Princeton University. I was on a working group there, and we went through trying to... It's important to recognize and think that these technical solutions, if there are to be any, with respect to these different platforms, are not going to be the same. So the solution with respect to a device is going to be different from an end-to-end encrypted messaging app, for example, versus secure encrypted video or something. So they're going to be different technical solutions. Figuring out how to collect communications in transit is the hardest problem, technically, to try to reconcile all these different equities. And so what the working group suggested was to focus on device encryption where the government has lawful possession of the device, not trying to access it remotely, but where it has lawful possession of it. We were unable to find and do not know of an actual solution, but with respect to the various possibilities, that's the one where I think governments should be working together cooperatively in a transparent way. I agree completely that transparency is essential here with respect to a viable technical solution, but that's most likely the area where we should focus on. So as you're thinking about the debate, it's not going to be a one-size-fits-all technical solution for encryption or encrypted messaging apps or devices. It's got to be a nuanced, highly technical, highly rigorous review. And so I recommend for the governments here and any other governments that want to be involved in this that we would work with, pulling people together and actually sitting down and putting forward proposals and subjecting them to the kind of rigorous testing that Danny was talking about before, where they've all failed so far. But that's, I think, you've got to actually sit down and start to work through real potential solutions and not just issue proclamations or pass a law or whatever. Congress can pass whatever law they want. It doesn't mean that the problem's going to go away tomorrow.
I want to switch gears real quick. I have a question for Sujit. AG Barr has made it clear he thinks two major pillars of tech policy, that being encryption and Section 230 of the Communications Decency Act, pose problems for law enforcement and give the tech industry too much power. How might the discussions around child exploitation, Section 230, and encryption all collide? How do they relate to each other?
Well, Section 230 is obviously the subject of a lot of public discussion right now, bipartisan discussion. Law has been on the books for over 25 years now, and I think there's a sense in which that public policy discussion needs to be reinvigorated. The immunity that Section 230 offers has been interpreted by courts, I think, in a particularly broad way. Some proponents of the way that certain courts have interpreted have said that's led to the internet that we know. Opponents of those constructions believe that internet companies no longer need the protection of such broad liability, now that they're sort of mature, and that the expansion of 230 immunity has gone far beyond what Congress initially intended when it enacted the statute. So I think others have suggested that Section 230 has enabled platforms to absolve themselves of responsibility for policing their own platforms, while also letting them remove third-party content selectively and with impunity. So let me just say this, on behalf of the department, we share some of the concerns with the expansive interpretations of Section 230. I think it's reasonable to ask, does it make sense for Section 230, which initially, of course, was enacted to protect the Good Samaritan, to immunize platforms that make no effort to mitigate unlawful behavior or that intentionally blind themselves, as well as law enforcement, to illegal conduct occurring on or facilitated by the online spaces that they create. So within the Department of Justice, we are actively reviewing many different policy options as part of any potential amendments to Section 230, and we're looking at that actively within our team. Let me say this, we do plan to hold a workshop on Section 230 issues. The formal announcement will be coming shortly, where we want to encourage a diverse set of viewpoints so that we can internally decide on what position to take on 230. But there's no doubt that this is a very pressing public policy issue. It's one that is something that we are actively thinking about, and with good reason. There is bipartisan views out there that Section 230 is in need of reform.
We just have a couple minutes for questions. Carl?
Can one of us quickly respond to that?
Sure, sure.
Let's remember,
30
Section
seconds.
230, having worked with the organization that was a leading proponent of 230 when it was enacted, Section 230 was enacted to protect the free speech of internet users, and as you say, to encourage Good Samaritan behavior and to deal with some legal oddities at the time. I think the connection to this encryption issue is, a politically, perhaps a politically clever thing to do, but it doesn't change any of the questions we're talking about here. If there's going to be some set of requirements imposed in exchange for 230 protection, we still have to figure out what those requirements are and whether they're reasonable. So I think the 230 thing is a smokescreen in an effort to add some political zing to an issue which, as Jim has pointed out, Congress has not previously been able to address. And I don't think it's going to help matters. I think it's actually going to confuse matters.
Well, can I just say one thing? I wouldn't suggest that 230 and encryption are necessarily linked. I will say
that's the Lindsey Graham bill, so that, yes.
Well, or Senator Whitehouse. So this is a bipartisan issue. There was a hearing in December before the Senate Judiciary Committee where Senator Whitehouse straight up asked either the representative from Apple or Facebook who was there, you get all the upsides of 230 liability immunity. You have none of the downside, right? When your platforms are used for child sexual exploitation. So I'm just channeling Senator Whitehouse. I'm not, the Department of Justice is not in a position to take an official view on any of these issues. But, you know, it's not me saying it, it's members of Congress.
I'm just saying the linkage is a distraction, really. And it doesn't get us any further in answering these questions, which are hard questions. If anything, I think it muddies them.
And we can debate about that, but I would like the audience to be able to ask some questions.
Activity occurring on their platform and shield behind 230 just isn't factually accurate. But I do have a question for us going back to the original issue, which is kind of the false choice that's being presented. Either security or privacy is essentially what we're talking about. And one of the security issues that hasn't been addressed is the US intelligence agencies have said for the past 7 or 8 years, the greatest threat to the US infrastructure are cyber threats. That is a clear security issue. How does the movement to kind of pierce encryption run directly into the greatest threat for our infrastructure according to the cyber administrations?
Can I just jump real quick? I mean, as I think I referenced this and I've written about it, it makes it worse. It makes it much worse. And so, and because we don't have a solution, and because we're so vulnerable, and because Congress hasn't acted, that my view is that law enforcement needs to rethink its approach to encryption and actually embrace it, because our threats are so tremendous that encryption is one way. It's not the whole way, and it's not the only way. It's not a complete way, but it's one way to improve our cybersecurity posture and address the grave cybersecurity threats that you're referencing. I agree with you completely.
So one point on this that I think is really important is I think we can end up talking about two different distinct issues here. So I think the first thing I said was that we support strong encryption, and actually encryption is really important when we start having discussions about critical national infrastructure. But actually the considerations there are quite distinct to what we've been talking about on this panel, which is whether or not commodity commercial messaging services should impose encryption in a way that precludes all access to content. I think those are just two distinct issues.
It's not necessary. I mean, they don't preclude all access. And in fact, we have articles going back and forth frequently with headlines saying, third-party company maintains ability to break through private sector encryption. The next one is private sector evolves past this ability. The next one is third party redevelops hardware to continue to hack into devices. And the UK specifically not only has authority under the Investigatory Powers Act to hack into individual devices, you have bulk hacking authorities, which I, from a human rights perspective, have no idea still how they can be consistent with the necessary and proportionate standard that you laid out to begin with. Australia also has hacking. We know the US engages in hacking materials, even though they've pushed back very heavily against trying to have any sort of specific hacking framework that would better protect against the risks of hacking above and beyond other searches.
I'm sorry, I gotta get like 10 seconds. We gotta wrap up. We got another panel.
It's just a really important point, actually, because what you're talking about there is in our law, equipment interference, which is a really important power, actually, and it is subject to really strong safeguards. But actually, you've struck upon an important point, which is actually if companies start moving towards precluding access through direct requests, i.e. not complying with interception warrants, then the result of that is to force governments more and more towards having to gain direct access through powers such as equipment interference. And as you've just spelt out, actually that can present some cybersecurity risks in itself. So surely, in our view, it is better, it's more scalable, it's more sustainable, where companies have lawful access mechanisms, can respond directly to warrants, rather than pushing government agencies into a position where they are required to keep vulnerabilities on the shelf to exploit. And let's go back to the point that we started with. The impact of this is really severe. law enforcement agencies require access to content. It's how they can secure convictions against terrorists, pedophiles, and so on. That requirement's not going to go away. So if there isn't a lawful access mechanism, then those agencies will have to find other lawful means to gain access to the same content.
And due to timing, we're going to give the UK the last word, and that is our panel on encryption. Thank you.